So let's start with today's session. In today's session, we'll be looking at restoration of conjugal rights, judicial separation, void and voidable marriage, divorce. So let's get started with today's session with restoration of conjugal rights. So the word restoration means to restore something to its original state. Now, here we are talking about marriage under Hindu Act. So, restoration of conjugal rights means restoring the marriage obligations, cohabitation in the marriage. Okay, so Section 9 of Hindu Marriage Act 1955 clearly states a restoration of conjugal rights. Now, the main intention of conjugal rights is to protect the marriage. Okay, it is the least intention to see that there's a divorce or there is a judicial separation. So the main intention behind restoration of conjugal rights is to preserve the marriage, to see that the marriage tie is not broken. It aims to preserve the marriage and not to dissolve it. Okay, so it refers to restoration of marriage obligations. Means once two parties have entered into a marriage, so they have few duties to perform against each other. So those marriage obligations, when they are affected, so that brings into light restoration of conjugal rights. And if there are other issues in cohabitation, if the parties are having issues in cohabiting, so in that case also restoration of conjugal rights come in picture. Now, there are some conditions on which restoration of conjugal rights is granted. So first one is withdrawal of the husband or wife from the society without reasonable excuse. Now, without any proper reason, so if the husband or wife have stopped performing their marital duties or marital obligations, or have stopped cohabiting with each other, so in that case, there is a provision to apply for restoration of conjugal rights. Okay, and it cannot be applied on legal grounds. Okay, you cannot, or legal petition. So you cannot ask for restoration of conjugal rights on legal grounds. Now, whatever is mentioned in the application for restoration of conjugal rights, so that should be true. You cannot ask for, or you cannot approach a court, okay, asking for false statements or furnishing false information and asking the court to provide restoration of conjugal rights. Moving further, burden of proof. So under restoration of conjugal rights, so if an applicant has moved to the court requesting restitution of conjugal rights, now the burden lies on the respondent. Like, say, suppose a wife has left the home due to some issues and she started living with father or parents. Now, in this case, the court will ask the wife, okay, so what is the reason why she has deserted her husband and why she is living with her parents? Now, here, what is happening? The burden of the proof. So who has to give a reason? Who has to give a valid reason? Wife has to give a valid reason. Wife has to convince the court that the reason is so and so, because of which I don't intend to live with my husband. If the court is satisfied, then the court will move forward to award or decree the restoration of conjugal rights. So lies the burden of the proof, as we have discussed, lies on the person who has was withdrawn from the society of the other. Now, in a landmark case of Anna Saheb versus Tarabai, 1970, Madhya Pradesh 36. So, the wife in this case has left the husband on the grounds that she doesn't like her husband and she doesn't want to live with him. The court ordered the wife to live with her husband and further added that she cannot desert in the sense she cannot leave her husband on the ground that she does not like him. So, in this case, it's very evident that the reason which the lady has furnished or the wife Tarabai has furnished here is not valid. So the court said in this situation, the reason which you are given, the burden of proof which you have kept behind before the court is not valid. So hence restoration of conjugal rights may not be applicable. Now let's move on further. Restoration of conjugal rights are not granted. In which situations conjugal rights are not granted? So first condition or first situation is husband's inability to cohabit with wife. Husband's inability in the sense, so there may be various reasons because of which the bonding between the two parties is affected. Okay, so they are not able to. Husband is not able to. Husband or wife are not able to get along in the cohabitation. So there are cohabitation issues. Okay, in that case, okay, so like a restoration of conjugal grants or conjugal rights may not be granted. Cruelty or false allegation of unchastity. Cruelty. Now, the behavior of sometimes the behavior of husband becomes abnormal. So he may start beating up his wife. He may start verbally abusing her. He may start torturing her either in a physical or in a mental level. So on that grounds also, it is possible that the court may not provide restoration of conjugal rights. And the third one is undesirable act of husband. So if the husband or one of the marriage partners is his behavior is insane, or they are behaving in an abnormal way and creating a problem to the other marriage party, or a situation where there is a risk to the life of one of the marriage parties. So in that situation also, restoration of conjugal rights will not be granted. So indecent behavior, like one of the marriage parties starts abusing the other party or doesn't respect the other party or misbehaves with the other party or doesn't follow the marriage obligations. Okay, and whenever it opportunity turns up, leaves no scope to look down on the other party. So in such situation also, restoration of conjugal rights may not be granted. Insanity, if one of the marriage partners uh, have lost their mental balance, okay, they are not in a situation to take care of themselves. So when they can or not in a situation to take care of themselves, obviously cohabitation may not be possible, fulfilling the marriage obligations may not be possible. So in this case also, restoration of conjugal rights may not be granted. Next, if one of the party makes false charges against respondent of committing an unnatural offense. So in that case, in this case also, restoration of conjugal rights may not be granted. Okay. Now, so generally, there is a question raised whether Section 9 of Hindu Marriage Act 1955 is constitutionally valid or not. Okay, so Now, it is very clearly established in the case of T. Sarita versus T. Venkatasubbiah, 1983, Andhra Pradesh 556. So, in this case, Sarita married Mr. Venkat Subbaya in 1975. So, later, after a few years, they got separated. After getting separated, okay, the husband filed petition for restoration of conjugal rights because her husband was in a situation to preserve the marriage. So he has filed a petition for restoration of conjugal rights in the court. Okay, so when he applied for when he applied for um, when he applied for restoration of conjugal rights, okay, the court had given an verdict in the favor of the wife, okay, and it has struck down section 9 as the court gave a verdict that it was violative of article 14 and article 21 of Indian Penal Code of Indian Constitution. So this was one of the cases which was widely in discussion in the legal world and had raised many questions on constitutional validity. Okay. Next, let's move on with judicial separation. Judicial separation will arise where one of the parties is not prepared to fulfill the marriage obligations or cohabitation. So it is not an end to the marriage, but it is a temporary separation, at least for few months or a year, so that the parties get sufficient time, okay, to reconcile, okay, and they may drop the idea of divorce between like before the judicial separation period is completed. So basically, it is termination of marital obligation by court. Okay. And the main intention of judicial separation is to preserve the marriage bond. Now, other sections which are related with judicial separation are section 13 1A first 1A subclause 1 and section 13A section 13 1A subclause 1. So after 1 year, okay, after 1 year of judicial separation, if both the parties have not cohabited or they have not fulfilled uh, marriage obligations. So in this case, the court allows the parties to get divorced. And this is here the thing to be noted as after the period of judicial separation. If the two parties were given as judicial separation for 1 year, but the parties didn't utilize or didn't get into cohabitation or didn't follow the marriage obligations. So in such a situation, under section 13(1)(a) subclause 1, so divorce is possible. They can go for divorce. And 13(1)(a) talks about judicial separation. So here also there'll be a judicial separation, and after the judicial separation, they can go for applying for the divorce. Okay. Now, as we have discussed, the main intention of judicial separation is not to encourage the parties to move towards divorce. The main intention here is to preserve the marriage, but not to dissolve the marriage. Okay. Judicial separation is given to, or can be considered as to give an internal or interval to the parties for deciding reconciliation. Reconciliation means, so like wherever there's a least possibility of dropping the idea of divorce. So the court will be in a favor always of preserving the bondage, but not dissolving the bondage. Now, in which cases judicial separation is granted? Now, there are two situations where judicial separation is granted. So, Section 31 1, okay, so which can be which is available or which is open for both wife and husband, and Section 13(2), which is open only for wife. So, under Section 13(1), so they can file for judicial separation on the charges or in case of adultery. So adultery is where one of the parties have has not been like like, is he trying to cheat the other party, or is he or she have or like they're like getting into illegal relationship with other, and when this other party, okay, when this is noted, like say suppose husband red-handedly catches wife in an act which is not acceptable or in a compromised situation. So in when he has got sufficient evidence about that compromised situation, then he can file for judicial separation. And in most of the cases, if the court finds it right, judicial separation will be awarded. Cruelty. So if the behavior of one of the parties, marriage parties, is not in an expected manner. Okay, like for example, if there is a sexual harassment, the husband is harassing wife on sexual grounds, or there is a marital rape, okay, or indecent behavior, okay, verbal and physical abuse beyond the state of tolerance, then the wife or other spouse can apply for judicial separation. Desertion. Desertion is like when one of the parties has moved away and is not ready to support the other party. He's not bothered about maintenance. He's not taking care of the other party. Then in that case, one of the parties can move to the court and apply for judicial separation. Conversion. One of the marriage parties, okay, have converted to other religion, or have uh, converted from Hinduism to Islam, or have converted from Hinduism to Christianity. Now, in this case, the other party, the other spouse, can apply or can approach the court and ask for judicial separation. Insanity. Now, one of the marriage parties have lost their mental balance, or a situation where one of the parties are not in a position to take care of themselves. When they are not in a position to take care of themselves, it is quite possible that they may not justify uh, the responsibilities related to cohabitation or responsibilities related to marriage obligations. So they may not be able to fulfill either cohabitation or marriage obligations. So in this case also, one of the spouse can move to the court and seek judicial separation. Leprosy. If, God forbidden, one of the marriage parties had become a victim of leprosy, okay, so they got the disease of leprosy, which is contagious. So in this case also, they can move to the court and the court will uh, grant judicial separation. Next, venereal diseases. Okay, so if one of the parties has become victim of venereal diseases and there is no chance of recovering for it, and it is affecting cohabitation and it is affecting marriage obligations. So in this case, the court can grant judicial separation, which is open. All the seven which we have discussed, these are open for both husband and wife. Okay, this may be an issue either with the husband or with the wife. Both can approach under Section 31 of Hindu Marriage Act 1955 for judicial separation. Okay, renunciation of world. Renunciation of world, like one of the marriage parties uh, likes, like is not interested in materialistic life. So he wants to abandon everything and he wants to lead a religious life. He or she wants to lead a religious life, not fulfilling the essential conditions of marriage, such as cohabitation or fulfilling marriage obligations. So in this case also, both the parties have an provision to apply for judicial separation. Okay. Now, if a person is missing for 7 years, there is no information about a person for 7 years. So in that case, it becomes a valid ground to apply for judicial separation. Now, these nine are the situations which are on which a person can uh, apply for judicial separation. Now, there are four provisions which are open, so which are specifically given to wife. So, 13.2, Section 13.2 of Hindu Marriage Act 1955 gives four valid grounds for a wife to apply for judicial separation. One is bigamy. So we have already discussed Hindu Marriage Act of 1955 talks or allows only monogamy. Okay. And it's a punishable crime under Hindu Act for a second marriage. So Hindu Act doesn't recognize a second marriage. And if someone performs a second marriage when the first wife is alive. So in such a situation, the marriage becomes voidable. Okay. So under bigamy, a situation where the husband has married or entered into a second marriage in the presence of the first wife, when the first wife was alive. So it becomes bigamy, and under section 13.2, subclause 1, so they can go for applying for judicial separation. Next one, sexual offenses. So if one of the marriage parties, like let us say the husband's behavior becomes abnormal, so he starts sexually harassing his wife. He gets into like uh, like the most not never expected behaviors like marital rape or sobriety. Okay, so in all these cases, so which are not considered for the healthy relationship of a wife and husband, where one of the spouse is not able to tolerate the extreme harassment that is done. So in that case, the wife has a provision to approach the court for judicial separation. And third, order awarding maintenance. Now, in one of the situations, so the court has ordered one of the parties to give the maintenance. And in case of failure of fulfilling the maintenance, one of like the wife is like, say, suppose there is a situation where the court has ordered to give a certain amount as maintenance to the wife, uh, to the husband. Now, in a scenario where the husband is not following the court orders, he's not giving the said maintenance amount to the wife. So in that case, the case will be open, or the case, a lady wife will have the liberty to approach the court to file for judicial separation. Repudiation of marriage. Repudiation means cancellation. Now, there may be some situations where the differences or the bitterness between the two parties has gone to an extreme level, unbearable or intolerable level. So in that case, the Indian Constitution gives a right to the wife to dissolve or to ask for judicial separation. Repudiation means cancellation. So now let us. So we have seen 9 situations which are open for both wife and husband. We have seen four situations which are open for only wife. Now, in the case of Rohini Kumari versus Narendra Singh, 1970, so 102. So what happened in this case was, so Rohini Kumari and Narendra Singh got married in the year 1945. And after 2 years, in 1947, the respondent, that is the spouse, wife, left the house of the appellant with all her belongings to her father's house. And after that, appellant, that is the husband, made many efforts to bring her back, but all the efforts went in vain. So they did not uh, fetch a positive result. So appellant married, so seeing that the first marriage is not going to be fruitful, the appellant married another woman. Now, once the first wife came to know about the second marriage, so she filed a case against her husband, stating that it was because of her father-in-law's ill treatment, and she was sent her away. So she tried to blame the father-in-law in this situation, and she created an allegation that because of her father-in-law's ill treatment, she was forced to leave the house. And later on, when the case was brought in the court, okay, when the case was brought in the court, and obviously the burden of proof here lies on Rohini Kumari. So she failed to prove the allegations. So whatever the allegations that were made in the court, she proved to fail. She proved to fail prove those allegations. Okay. So, and on the other side, the husband was successful. The husband was successful to prove that what she said was wrong, and she herself has willingly left the house. Now, in this case, the Supreme Court held that desertion for desertion consideration for desertion to be considered, it should be based on two essential conditions. So one is factum of desertion. So there should be a valid reason for desertion. So in that case, if the reason is valid, then the court may look further whether to go with grand judicial separation or not. Second one is animus descending. So there should be some sort of abnormal behavior. Okay, so some sort of uh, a behavior which may be threatful or which may be not considered normal or which cannot be tolerable, and wherein which creates a risk of a life to one of the parties. So in that two situations, like to apply for or to be eligible for judicial separation, so the court had laid two essential conditions. One is factum of desertion, and other one is animus descending. So the court decided in the favor of husband. Why? So here, the wife or respondent failed to prove the burden of proof. So whatever the allegations that she made about her father-in-law were proved to be false allegations. So hence, judicial separation was ruled out. Sorry, I meant to say judicial separation was awarded. Okay. The court decided, okay, so the court decided the case in the favor of husband. Now, let us move on to see what is a void and voidable marriage. Okay, Section 5, 1, 4, and 5 subsections of Hindu Marriage Act 1955 declare a marriage, okay, as a void marriage. So void marriage in the sense, though we use the word marriage, so a void marriage is something which never existed in the eyes of law. So void marriage is a no marriage in the eye of law. Means the law doesn't consider it as a valid marriage. So why? Because it was never it never followed the legal conditions. So in the absence of legal conditions, it cannot become a valid marriage in the eyes of law. Okay. Now, what are the situations? What are the conditions where a marriage becomes void? So, Section 11 of Hindu Marriage Act 1955 lays down three conditions where a marriage turns to be void. The three conditions are: first, violation of monogamy rule. So, if a marriage party or one of the marriage, like if the husband, in the case of first wife alive, he enters into a second marriage, okay, without giving divorce to the first wife, if he remarries another a lady or he enters into a second marriage. So in this case also, um, the marriage becomes void. And the next one is a violation of Sapinda relationship. So we have already discussed Sapinda relationship. Sapinda is within the same family. So what was the condition? So the subject should not marry with someone on the further line till 5 generations. In the same family, the subject should not marry uh, on the father side till 5 generations, and on the mother side 3 generations. And subject is also considered as the first generation. Okay, so the generations counting start with the subject. And the second one is, third one is violation of prohibited degree of relationship. Now, if the marriage is going to be solemnized and prohibited degree of relationship. This we have discussed earlier. Like, and niece cannot marry uncle. Okay, niece cannot marry aunt. The same way, brothers and sisters, children cannot marry. So in both the situations, the marriage will become void. Now, next, move on with voidable marriage. Okay. Now we have seen the void marriage. In simple words, void marriage is a marriage which never was considered to be a valid marriage in the eyes of law. Law doesn't recognize it as a marriage at all, or law doesn't give the status of a marriage to a void marriage. Okay. Voidable marriage. Voidable marriages or marriages which are valid, but based on some conditions, based on some changes, a valid marriage can be turned into a void marriage. So when a valid marriage is turned into a void marriage, it becomes an voidable marriage. Now, Section 12 of Hindu Marriage Act 1955 lays down clear conditions and essentials for a valid voidable marriage. Okay, a voidable marriage is one which is valid until repudiated. Means the marriage is valid in the eyes of law. Okay, and wherein marriage obligations are fulfilled, cohabitation is fulfilled, and it is an entity. It exists in the eyes of law. Till which point? Till the point of repudiated. Repudiated in the sense till it is cancelled. Once it is cancelled, then it will become an invalid in the eyes of law. Now, what are the grounds for voidable marriage? So there are three grounds: impotency of impotency of the other party. Now, if the husband, due to some reasons, is not in a position to perform cohabitation, okay, he's not able to fulfill the essential cohabitation conditions in a valid marriage. So that becomes a valid ground for applying or, for making the marriage as voidable. Second, unknown wife pregnancy. Okay, so if the roots of pregnancy cannot be properly traced, or the roots are pointing to someone, not to the husband. Okay, in that case, also it becomes a valid ground which will nullify the marriage. And the third one is lack of free consent. Now, the both the parties entering into marriage should give a free consent. They should give a very clear consent, willingness for the marriage. In the failure of one of the parties not giving the consent, then also the marriage becomes void. Okay. Now, there may a question arise about the children. What will be the status of the children if the marriage becomes uh, voidable? Now, in the both the situations, or whatever maybe the three above discussed situations, children born out of voidable marriage will always be considered as legitimate. Okay, now let us look at one of the case related to voidable marriage. So, Mr. Mahendra versus Susila. So, 1965, case number 364. Okay. Now, in this case, they were married, and after solemnization of marriage, just after 171 days of the marriage, a child was born, and the growth of the child was normal. So generally, it takes 9 months for a child to be born. So 9 months, in the sense, it comes more than 200 days. Okay, but in this case, the child was normal, and the birth or the delivery had happened. The gestation, after complete gestation, the child had born. So what does it mean? It means that the lady or the wife who had entered into the marriage, so she would have been pregnant before the marriage itself. Okay, so she concealed it. She did not reveal the fact that she was carrying or she was pregnant at the time of marriage. So in this case, the Supreme Court held that the bride should have been pregnant at the marriage. So it's very clear, because if the child is normal, then the duration of gestation, the duration of pregnancy should have been complete, because the child was normal. So it gives a direct conclusion that the lady had uh, concealed the fact that she was pregnant. Second, husband was not aware. Okay, so the pregnancy was concealed. It was hidden. It was not revealed to the husband. And the third, whenever such a situation arises, so the petition should be, or it should be brought to the notice of the court within 1 year. So they should not be like one cannot approach a court after 2 years, stating that he is not my child, or there is an issue in the child's birth, or he doesn't belong to me. Okay, so it should be brought to the notice of the law within 1 year. Okay, and after the condition of the wife is known, after it is understood that the wife is pregnant, so in such a case, okay, there should not be any marital intercourse. So the other party should not force or should not enter into marital intercourse with the wife, okay, knowing her condition. Next, let's move on with divorce. Okay, so Section 13 of Hindu Marriage Act 1955 deals with divorce. Okay, so what is divorce? So there is no concept of divorce under the old or ancient Hindu law or ancient Hindu schools. Okay, so under uncodified Hindu law, divorce was not recognized, because Hinduism believes in living together, or once a marriage is uh, perform, it is considered to be a sacred obligation. Okay, only in exceptional cases, okay, when the custom allows, there can be a separation. But generally, Hindu marriages are against divorce. Okay, so very, very exceptional cases, it may be allowed. So what does a divorce do? So divorce actually dissolves the marriage tie. So divorce is a permanent separation. Okay, so after the fulfillment of divorce in a court, so the it ends the marital obligations. So the two parties which have been sharing a common life now are separated, now or independent. So they will lose the rights and concerns on each other, and both of them, after the fulfillment of divorce formality, will be two separate entities, two separate individuals who are nowhere or in no way connected with each other. Okay, so ends marital obligations between the parties to the marriage. So marital obligations, so marriage related obligations, rituals, okay, traditions, cultures, all will be vanished, and it also puts an end to cohabitation. So it is retrospective in operation. Next. So when we talk about divorce can be possible in three different situations. Divorce can be applied under Section 13(1), Section 13(2), Section 13(b). So Section 13(1) is open for both wife and husband. Okay, so divorce can be applied on the grounds of adultery, on the grounds of cruelty, on the grounds of desertion, conversion, when one of the marriage parties has embraced another religion other than Hinduism. So in that case also, a divorce can be applied. Insanity, when one of the person loses his mental balance. Leprosy, when one of the person becomes a victim of a disease like leprosy, which is contagious, then also they can apply for leprosy or apply for divorce. Okay, venereal disease, when one is a victim of venereal disease, so then also they can go for divorce. Renunciation of wealth, so when one of the parties has given away his marital obligations, or he's nowhere interested in to lead a materialistic life, or where he has become more religious in nature. So on that grounds also, divorce can be applied. Unheard for 7 years, if one of the parties has gone missing for more than 7 years, so uh, on this ground also divorce can be applied. Okay, after decree of judicial separation, so when judicial separation was given, and after completion of 1 year of separation, so if the court sees there was no cohabitation, there was no fulfillment of marriage obligation, then the case is open for divorce. Okay, so after a decree of restitution of conjugal rights, so like the court has given restitution of conjugal rights. Now, after the set time of conjugal rights, if both the parties feel that they cannot be together, now on that ground also they can apply for divorce. Now, for women, there are four clauses under which they can apply for divorce. One, bigamy. If the husband has solemnized a second marriage when the first wife was alive, so monogamy is allowed in Hindu Marriage Act of 1955. Bigamy is marrying second or entering into a second marriage when the first wife is alive, so which is a punishable crime. Now, if the husband has entered into a second marriage when the first wife was alive, then the first wife can apply for divorce. Sexual offense. So if one of the parties, okay, behavior has changed and he or she starts harassing the other party, uh, sexually abusing or marital rape or severity, okay, then these are all the valid grounds for the woman to apply for the divorce. So order awarding maintenance. So whenever there is uh, not fulfillment of the order which is awarded for maintenance. So if the husband is not fulfilling the maintenance which he is supposed to give or which has been ordered by the court, so in this case also uh, the wife can apply for divorce. And Section 13B of Hindu Marriage Act 1955 gives a provision of mutual consent to both the parties to apply for a divorce. So mutual consent, when we say, when both the parties have come to an understanding that they no longer can be together and they want to be separated, they want to end the marriage at any cost. So where there is least possibility of fulfilling marriage obligations or cohabitation. Now, it should be a condition of both the parties. If both the parties decide and they stick to end the marriage, so they can file or they can apply for divorce under 13B.